My name is Irwin Ironstone. That's the handle that I go under, although my name really is Irwin Ironstone, which means ironstone. Here today to talk about a very specific rule in the Florida Courts of Appellate Procedure. And because it may be good in Florida Courts of Appellate Procedure, it's possible that it can also be good in the lower circuit courts. Okay, the rule I'm going to talk about, and I'll read it into the record here, is Appellate Rule 9.200B, little b, parentheses 5. It says statement of evidence or proceedings. If no report of the proceeding was made, or if the transcript is unavailable, a party may prepare a statement of the evidence or proceedings from the best available means, including the party's recollection. In other words, if you remember it, you can put it down. The statement shall be served on the other parties who may serve objections or proposed amendments to it within 15 days of service. Therefore, the statement and any objections or proposed amendments shall be filed with the lower tribunal for statement, settlement, and approval. As settled and approved, the statement shall be included by the clerk of the lower tribunal in the record. And you say, why am I reading this in here? Well, it's fascinating. Because of COVID and the way the courts are being handled, many hearings are done remotely. And in remote hearings, a party can not only, get a transcriber, but can actually get a recording of the hearing as it's going on. Now, what happened in this case, and I just call it Sarah's case, she's asking for the appellate court to accept the transcripts that she has drafted and submitted to the lower court previously, according to Rule 9.200, open parentheses, small b, open parentheses 5, statement of evidence of proceedings. And what that means is if you're poor, and a lot of people in Florida are poor and can't basically afford a transcript, there's now a mechanism where if you can get a recording of that hearing, you can transcribe it yourself. I'm sure judges may not like it, and I'm sure rich insurance companies may not like it, but this is opening up the courts to those who can't currently afford to do things in court. The transcripts are based upon hearings that Sarah made from the hearing of such and such and such and such. These two hearings were closed and held remotely because of COVID virus. Sarah submitted a transcript of the hearings with a zip drive of the hearings. Zip is a small drive where you can capture audio, video, to the lower court. No objections were filed by the parties. In other words, the lawyer for the other side didn't file an objection. Sarah is pro se in this matter, which means she probably either couldn't get a lawyer or couldn't afford a lawyer. Sarah's recorded her remote hearings because she was not able to pay for a transcriber. She's been declared indigent in the courts. She then used the recordings, listened to them, and wrote them down or typed them, and she produced transcripts. This process is available to people who cannot afford the cost of court-ordered transcripts. Although the audio recordings are not the best available recordings, the transcripts that Sarah made are probably the second best record record of the hearings. The first best would probably be a video recording, but since videos are not allowed in many courts, this gives the party at least the second best choice. The audio recording itself is better than the written transcript because it contains many language cues that are not present in the written transcript. In fact, Sarah has found research done by linguists that verifies that language cues appearing in a voice recording are not available in a standard transcript. Even if someone is smart enough to know it, like saying, "Why are you raising your voice?" very few people do that. But if you have a recording, that's there. The cues that can be found by listening to a recording include the volume of the speaker's voice. I've seen judges raise their voices and almost scream at people. The tone of the speaker's voice. "You're crazy, I'll never accept that." Interruption patterns of the speaker and the control of the courtroom by the speakers. Very frequently, a judge is likely to interrupt a non-attorney because the non-attorney is not as smooth as an attorney and doesn't know how to speak court speak. And let me just go on to say the U.S. Supreme Court has noted that transcripts may not be sufficient. In a case called In Re Little, that was from 1972, and the site is 404 U.S. 553, 556. Justice Berger, who at that point was Chief Justice, said, "Those present often have a totally different impression of the events from what would appear even in a faithful transcript of the record. Some measure of the flavor of what really occurred in this episode and of the petitioner's attitude and demeanor, how his spoken words impressed those present, may be gleaned from the events and utterances described in the court's per curiam opinion." Per curiam means it's by the court opinion. And what that says basically is transcribers occasionally screw up. I've known to do things purposely and screw up, favoring one party over another. Based upon the availability of audio recording, the appellant is requesting an order from this court, which is an appellate court, to allow her to audio or video record any future hearings that are held in the Ninth Circuit. Additionally, Sarah requests that this court accept the transcripts as part of the record. And the other side has a chance usually to object. They haven't so far, but the appellate court, in fairness, has said, "Do you want to object?" Okay. Next we go into en-banc requests. En-banc is when you want the entire members, all members of the court, to hear a case. Usually on the appellate courts, only 3 judges hear it. If the court denies this request, Sarah, the appellant, would request that this issue be reviewed by the entire court or be sent to the Florida Supreme Court for review. The issue is one that impacts a significant number of individuals who cannot afford to pay for transcripts and are denied due process. And I cited Sarah cited 2 Supreme Court cases. Both of them have to do with procedural rulings and when a court can and can't make some modifications. One of them is Matthews versus Eldridge, and the site there is 424 U.S. 319, and it was in 1976. Another case where the court had some procedural issues was in Turner versus Rogers, And the site there is 564 US 431, and that was in 2011. That case had to do with child support, where Turner was continually being locked up and put in jail, and he felt he was not being given a chance to argue his case. That happens occasionally, more than not. There are probably 30 or 40,000, fathers who were put in jail at one point or another, and they have to argue against it. In any case, the appellant, Sarah, respectfully requests this honorable court the use of her transcripts on several days, and she wants the court to issue an order allowing her to record any future hearings in the Ninth Circuit and grant her any other such relief that the court may think is necessary. And she says here certification. She served the other parties. The other party is a big insurance company, Florida Farm Bureau, and I don't believe their lawyer has been ethical in certain ways, but it's very hard to get a judge to realize or to see that lawyers frequently aren't ethical. And there are times when judges clearly favor a large company over a single individual who can't afford a lawyer, who can't afford medical treatment. And this was an accident, auto accident, and I'll talk about a little more about that later, because I think this insurance company didn't act fairly or according to the law. Okay, and it was certified by Sarah, and that's all for now. If you have any questions, you can email me at ironston44@gmail.com. There are times I think that our legal system, by the way, I'm not an attorney, but I did go to law school and I passed at least 2 bar exams. I believe the Florida court, in my case, didn't want me to be a lawyer in Florida because I've sued judges and I've sued attorneys because they frequently make errors, misrepresent the truth, and take advantage of those who can't afford lawyers. Okay, that's all I wanted to say. Thank you for paying attention, and that's all now.